Sorry, I couldn't set up the virtual background. This session.
Dear participants, a very warm welcome to all of you here at the AIADR Third Online Fellowship Roundtable Series, Psychology in Arbitration. My name is Wan Ying and I will be your host today. Before we start, I would like to remind all participants of the housekeeping rules for a better experience of the Roundtable Series. First, please keep yourself muted during the panel discussion. You could use the raise hand function or put your questions in the chat box if you have any questions. The speakers will address your questions during the Q&A session. Second, after the panel session, it will be followed by a 10 to 15 minutes Q&A session. Participants are welcome to unmute yourself to pose your question to the speakers or bring up questions that you would like to discuss to the floor. Third, please be informed that only the panel session will be recorded and uploaded to the AIADR YouTube channel. Your cooperation is much appreciated. We shall now begin by inviting Mr. Hamdan, the director of the event, to deliver a welcome remark.
Thanks, Wan Ying. On behalf of AIADR, I would like to thank all our distinguished panel of speakers and the moderator and participants. Psychology in arbitration is a very interesting topic. As we know, emotions play a key role in adversarial approach, especially in arbitrations. So we have a very experienced set of panel members here to share their experience. So I would pass back to Wan Ying to call upon Simon for further introduction of the panel. Thank you.
Thank you, Mr. Hamdan, for the wonderful welcome remark. Without further ado, I would like to invite the moderator of this session, Mr. Simon Elliott, and panelists Oliver Bothausen, Dr. Christopher Malcolm, Yoshihiro Takatori, and Sisha Qureshi to the floor. Mr. Simon is a partner in the Singapore office of Three Crowns LLP. He mainly focuses on disputes arising out of large infrastructure and other major projects involving dispute technical, delay, and quantum-related issue. He is also admitted and entitled to practice at both the Paris Bar as an advocate and in England and Wales as a solicitor. Mr. Simon, the floor is yours.
Thank you very much, Wan Ning and Mr. Hamdan. And hello to all of our participants today. The most studies of arbitration are devoted to discussions about the applicable law or the various procedural rules. It seems far more important to try to analyze how and why arbitrators make up their minds. This is a quote from Robert Coulson, who was the president of the American Bar Association. It's from 1990. The sentiment was prescient and the idea that it captured fundamental. Since 1990, when Mr. Coulson was writing, attention has increasingly turned towards the role that psychology plays in arbitration and other adjudicative processes, central to all of which is a decision. And because that decision is made by a human mind, understanding the role that psychology plays is crucial. So we have a really fascinating topic for discussion today and the good fortune of an esteemed panel who are going to share their insights and wisdom with us. First off, we have Oliver Bolthausen, who's the Global Head of Arbitration and Deputy Global Head of Dispute Resolution at DWF. Oliver has both civil and common law training and usefully for today's purposes also has a background in psychology. Now, in addition to his work as counsel, Oliver sits as arbitrator and also works in the field of business mediation. We also have with us today Yoshi Takatori. Yoshi is an attorney at law and also spans the civil common law divide, being admitted in both New York and Japan. After some time heading the dispute resolution practices at international firms in Tokyo, Yoshi established the International Arbitration Chambers in Kilo in May 2020. He specializes in cross-border litigation and works as both mediator and arbitrator. Next up on the panel, we have Dr. Christopher Malcolm. Now, Chris is a former Attorney General of the British Virgin Islands and is currently the Deputy Dean and Director of the Mona Law Institute's unit and a senior lecturer at the Law Faculty of the University of the West Indies. Chris has extensive experience as counsel and mediator and arbitrator. Finally, we have Sursha Qureshi. Sursha leads PwC's Dispute Advisory Center for Excellence. He has extensive experience acting as an expert in financial and accounting matters and disputes around the world. He's been involved in and testified in commercial and investment treaty disputes and has also acted as expert determiner in share purchase agreement disputes. So, in line with the breadth and experience of expertise of our panelists, we're going to address the topic of psychology and arbitration from the perspective of arbitrators, counsel, and experts. As Wan Ning said, we're going to leave some time at the end for Q&A, so feel free to participate in that session. So let's begin our topic today, our discussion today, with a definition of what we mean by psychology when we speak about psychology and arbitration. Oliver, would you like to lead us off?
Sure. First of all, thanks, Simon, and thanks for having me. Talking about a topic which is close to my heart with this esteemed panelists is certainly fun. Psychology is a big word. I like a very short and brief definition of it. It's the study of mind and behavior, as well as conscious and unconscious phenomena. So that is a lot to fill an hour with. And we focus, I think, today a little bit of how we receive information and how we communicate, because everybody's communicating all day. We are communicating now via video. We are communicating in person, in writing, and also in different scenarios, like at trial, at home, with our children, with our spouse, on the soccer pitch. Not very good for the Germans at the moment, but that's a different topic. And all in board meetings or other arenas. So different cultures play a role, different environments, different people. Are you convincing? Are you negotiating? Are you fighting? Are you mediating? Are you teaching? Are you selling something? All this makes it very complex. But down the road, we boil it down to how information, communication is received and the brain works with such. So what, in my view, is important with this topic is that you have to be more aware of your communication and be more sensitive as to its effects on you and on others around you. And you will think much more about how to present, how to argue, and how to communicate if you have a little bit of background on how these effects are playing a role. The brain stores 2.5 million gigabytes of data. So there's no excuse for anybody to say, I forgot something. It's somewhere. The question is, can you raise it to the front? Can you raise it to the awareness of the arbitrator or the other counsel or the expert or the witness you are cross-examining? So it's critical for a lawyer or arbitrator to put the information, the communication, in a way that it is good and well remembered and worked with. So let's take a closer look real quick at how information is received. You might say, I'm taking my decisions very rational and I'm a lawyer, I make my conscious decisions. You are not. You're not in charge of your brain. The brain has its own mind. The brain often makes decisions before we can make such consciously ourselves. And the brain decides whom to trust and whom to not trust in the first place. Technically, it's oxytocin, which is emitted through the brain. So that's an element of trust, which we cannot have an influence on. So how does the brain deal with information? We have the 5 senses. We touch, smell, hear, taste, and see. And some say there's a 6th sense, but that's a different topic. These are the senses we receive information with. And I think for us as lawyers in a hearing and in a trial, we can focus on hearing and seeing as the most important ones. And then there is, some of you might have heard about it, Edgar Dale's famous cone of learning, cone of receiving information, of understanding, of learning. And it has an interesting element to it because it says only 10% of the information is well stored and worked with if it's read, 20% if it's heard, and 30% if it's seen by the eyes. And if you combine something that you present hearing and seeing, it is 50%. It's not reading and seeing, to be precise. It's seeing is a picture image, not reading, because that is a conscious decision you have to do. And 70% if you say it yourself, like I do it at the moment. I probably remember my own words much better than you do, hearing it. And the third element is the crown element is if you do something, you remember it and you work with it by 90%. So if you make somebody write, conclude, or calculate themselves, that's the best how you can make information with or stay with the arbitrator or the counsel. So 2 takeaway points. A PowerPoint presentation, where applicable, might help you to make them see and hear. Use pictures and keep your audience always active. Active means involved. And let the arbitrators, my tip is let the arbitrators draw their own conclusions. The tribunal, in my mind, needs to convince themselves. They need to be convinced themselves. So you lead to a certain point, and then you pause and let the conclusions be drawn, even subconsciously, in the mind of the arbitrator. That will stick with their brain, minds and heads. I'll leave it to that, Simon.
Thank you very much, Oliver. That was extremely interesting. You mentioned culture, and I'm interested to explore this topic a little bit. So Emmanuel Gaillard, in one of his books, described international arbitration as a social field involving a constellation of actors sharing a common meaning system. And in this social field, the constellation that Professor Gaillard talked about actually involves actors from a multiplicity of different legal and cultural backgrounds. And so I was interested in hearing from you, Yoshi. You've got decades of experience as counsel, arbitrator, and mediator in cross-cultural and cross-jurisdictional disputes across both the civil and common law domains. In your view, to what extent does cultural diversity influence psychology in the arbitration context?
Thank you very much, Simon. And first of all, it's a very much honor of me to be the one part of this session, and thanking to the Oliver's excellent definition and such factors for the psychology. As Simon mentioned, I have been experiencing the quite various jurisdictional and multi states and the nationalities, arbitration and the mediation, kind of a combination as well, even including the combination of the various nationality or culture backgrounds, arbitrators among the arbitrators panels, and advocates, counsels, and experts from the other countries or something. So just for the generally speaking, how to communicate and how to react and how to persuade the other parties or arbitrators, or from the arbitrators to the counsels, or how to catch the information from the witness something. And just one example is the how prioritize kind of a hand gestures or face looking and the voice volume and such kind of level and the reaction could be quite different depending upon the such different culture. For example, like in Japan, kind of silence could be regarded as a gold. That's kind of a saying. But when I was studying in the Harvard, silence could be regarded as a kind of a stupid, no information from yourself, something. So such quite drastic difference, not only such drastic difference, but, as Oliver mentioned, the consciously or unconsciously, some different and sometimes quite opposite direction of how you can catch some information or a sense. And also in Japan and some East Asian countries, written information could be more prioritized than the oral, communication. But in Europe or US or something, of course, the oral argument could be more prioritized. And also, just some Eastern Asian countries, advocates is a very kind of, sometimes talking very quickly and speedy. And that could be sounded like, oh, he seems to be angry or something. But the truth is not, true or something. So as the advocate and as the arbitrator and the mediator, you should catch kind of real sense. But of course, the consciously or unconsciously, you have quite sense through the, as Oliver mentioned, the five sense, like ear, eyes, face moving, and volume, the tone of the how you communicate or something. So it's quite important to how to think about it. For example, if you cross-examine the witness, then how you're asking could be sounding to the arbitrator and to the witness and to the advocate side or something. So that's a very quite general statement, but that's my first statement. Thank you.
Thank you, Yoshi, for those insights. I'd like to move on now to talk about psychology from the arbitrator's perspective. Numerous studies have found that psychological influences have an impact on the way arbitrators make decisions, and also by extension, the quality of their decisions. And I'd like to open this question up to all of the panel. In your experience, what are some ways in which psychology influences the way arbitrators decide disputes? I think you're on mute.
Oh, sorry. Thanks, Simon. If I may jump in a little bit,
Please do, Chris.
And I'm putting on my arbitrator hat for the minute. And one of the things I believe that in our tradition, Jamaica and across the Caribbean and elsewhere as well, I've found that we tend to tune in very well to good storytelling. And there's a psychology of how it is that you're able to tell a story so that it can be well received. Certainly, when I sit as an arbitrator, and I've found it even in litigation as well, when I've done litigation, and I used to do quite a lot of litigation at one point. I have found, and when I teach as well, if I were to translate it even there a little further, the idea is to remind myself and to tell others that I teach that the best case in terms of the substance of it is not always the one that wins. Very often it is the one that tells the best or most compelling story that can have persons feeling transfixed and believing themselves to be part of a story. And the best litigation advice, which I take into arbitration with me, certainly as counsel and I translate into the arbitrator as well, as to how I receive information, is always the idea of humanizing everything that I do. It may be about some piece of old iron or something. It's about creating a humanized story so that the receiver, being the arbitrator, can see him or herself in that story and being transfixed by it. And I think as arbitrators, we're constantly, in a very subconscious way, we're not only looking to receive the information as presented as fact and to hear the law and so on. We're also trying we're observing persons throughout the process. We're looking at all sorts of, not just how things are said, how we receive them in that very real way. We're also looking at behavior patterns. And subconsciously, we are thinking of, is this person telling a story that I want to believe? Is this person getting me to believe that this is something that actually happened? And I think certainly, especially when you get to these 50-50 decisions that you have to make, it always very often comes down to whose story did I believe better? Or that is what it typically comes down to. So I as an arbitrator, I am always interested to see the weaving of a story and to hear it expressed to me in a way which tells me that I am better off going with this person, particularly where there's a difficult decision to be made, than the other person. And that is something that always appeals to me.
Yeah, if I may pitch in, absolutely. I think you can summarize it that story beats facts. That's in many studies, it has shown that a story beats a lot of facts. And one of the examples, which some of you might know, is the O.J. Simpson trial in the US, 1995, where O.J. Simpson, a famous US football player, has been accused of having murdered his girlfriend. And there was a long trial, like in the US, with cameras in, et cetera, and the defense attorney, Johnny Cochran at the time, made use of a few psychology elements by getting a positive verdict, by using a technique to say what I mentioned before, that you remember things when you hear them better than when you read them. He asked the jury to put the glove, which was found at the crime scene, it's a glove was drenched in blood. He asked his client to put it on video. And he repeated over and over again to say, if it doesn't fit, you must acquit. That was a famous sentence. I think if you read the minutes, it was repeated probably 100 times to the jury. And it's a rhyme, so you can remember rhymes and songs better than words. Yeah? That's what we all experience when we sing along a song. So he used that. And he used a picture that when the glove does not fit, automatically, subconsciously, there is the argument that you have to acquit. And that's an interesting element which was used there. By the way, the fact behind it was that because of the blood the leather glove shrunk and technically was not able to fit. But that got pushed to the side. The fact got pushed to the side due to the storytelling and the theater, in my view, which was created. And the other, if I may put another example, there has been a study, I think in Israel, no, in the US, with 100 federal court judges were given a very straightforward, non-convincing tort case. A man bought a regular canister, and while filling it with gasoline, the container exploded, and he sued the producer. And the judges were given the facts, and 100% dismissed the case because it was not convincing. And now they changed the scenario with the same, not the same, another 100 federal judges. This time, they introduced an evidence which was clearly procedural, not admissible, to say that before there was an accident at the factory with one of the canisters. And despite the fact that it has to be struck from the record and the evidence was not allowed in, with the same facts otherwise, 25% of the judges awarded now a claim. So the lesson learned from this is you cannot delete things from the record. You can delete them from the record, but not from the mind of the judges. So use that, even if it's a little bit pushy and somehow inadmissible. If you have a good point, bring it. It will be struck from the record, but it will be not eliminated completely from the minds of the judges. And that this example shows you how your brain works, irrespective of the fact that it should have been struck from the record. And these are psychological tools and elements you just have to be aware of, and you can make use of.
Interesting. I think I've heard it expressed that you can't unring the bell in relation to that very point, Oliver.
Yeah, absolutely.
Sasha, I think you were going to say something.
Yeah, I was just going to add, and first of all, I'd like to thank the AIADR for inviting me to this. And actually, it's been always it's about the preparation with these gentlemen here on the panel, and I've really quite enjoyed listening to their perspectives and coming at the same topic from different angles. And maybe just going on to what Oliver was saying. So I'm coming at it obviously as a quantum expert. So I'm not a lawyer, but certainly I'm in this environment or sort of social field, as Emmanuel Gaillard said. The point around the Oliver saying around putting something in, but more tactical. I know I've seen this, and we're looking at it. I'll come at it obviously from a boring numbers perspective. That, as you know, within the valuation world, if you have a certain case and you're to have a valuation date, and you only can use information up to that valuation date, so therefore cannot use hindsight, what happens afterwards. So this will be maybe for expropriation cases, if it's an investment treaty case. In those cases, though, it's interesting. I have seen it many a time. I even have heard arbitrators comment that, and I've seen it, the numbers presented, okay, well, let's assume hindsight. So it's agreed that hindsight shouldn't be used, but arbitrators are also interested to see, let's look behind the veil of what would have happened. So even though, and this is sort of echoing Oliver's point around, okay, it's not admissible per se directly, but I think it's tainting thinking about how the arbitrators are seeing things, and they're very interested, well, what would have happened anyway, even though that's not the, how it should be assessed. So that's maybe one comment directly dealing with what Oliver's saying. But talking about psychology, I see it from a numbers perspective, when maybe, as Chris was saying, a good story is told, the arbitrators are convinced by it, and they need to provide an award, and they wish to give an award. Now, what is fair? Now, obviously, I would say as an expert that there's some logic used about methodology and some logic about how you would get there, what assumptions should be used, and then a certain number is awarded. However, quite frequently, I may see a number which maybe the logic is not quite as robust as I would like it to be. And in which case, and I can see I'm only guessing that the arbitrators are thinking what is fair to be awarded in the situation. They could maybe come up with a number, and then maybe the logic comes a bit afterwards. So I do see that, and there's influence, not perfect from in my world. I'd like to be a bit scientific about it to make sure I understand, but certainly you can see that it's manifesting itself from an award perspective. Maybe I'll pass it back to you, Simon, at that point.
Thanks, Saoirse. I was just thinking about the point you made about the number, kind of the sense of where the number should be coming first, and then the reasoning or the logic following afterwards. And I know that in the field of psychology, there are kind of people who talk about there being two systems of thought that we use, one being an intuitive system, which operates very quickly and almost subconsciously, and the second being a deliberative system, which kind of follows afterwards and either amends the intuitive conclusions we reach or justifies those conclusions. And I wondered if that ties back into the point that Chris was making about storytelling and why we do that, because what we're trying to do is tap into that intuitive process, that intuitive system of thought, and appeal to that first, so that we get the tribunal to where they want to be ultimately, and that we then hope that the reasoning will follow. I don't know if you have any thought about that idea, Chris.
I do, Simon, and in fact, I quite agree with you that very often, certainly counsel, and preeminent or not preeminent, whatever the counsel is in the matter, you're always appealing to the senses of the arbitrator. And you're always, in fact, one of the techniques, for example, that persons use, and there's a lot of psychology to it, is you go into a matter sometimes and you see it and they throw everything but the kitchen sink at the arbitrator in terms of just throwing up, and then you sort of watch to see what it is that they latch onto, and you follow that train in terms of how you take your argument thereafter. And we see that happening quite a lot in proceedings. And it is getting back to that idea of trying to tap into the intuitive thinking of the tribunal, and then saying, well, now that I've got you caught, let me see how I can feed more to you of what you're clearly interested in, and sort of weed out those other things that, even though I consider them to be important from the perspective of fact and from the perspective of analogy and reasoning as I see it, I have come to recognize that you, Mr. Arbitrator or Ms. Arbitrator, you're not quite interested in that. So let me go there. And even in the litigation process, there are some judges that you appear before who you know are fact judges. There are others who are judges who are excited by the law. And one of the things you go into is to try to figure out very early, who is the judge that I'm before? Is that one who is not so much interested and say, I don't want to hear the law really, even though they may not say it, you recognize that that is a thinking. Or there are others who are much more into the philosophy of the law and that sort of thing. And once you've sort of figured out which person it is that you're dealing with, then you then channel your argument or refashion it, even if you have already made it, to ensure that you're tapping into the right place. Because if you find a judge, for example, who's a fact judge, and you then go off on this tangent of making all the deep philosophical legal argument, 10 chances to 1, and I know that's 10 to 1, 0, you are going to lose. You know, and we get back to that old math which was used when Federation was broken up in the Caribbean, where at the time the Prime Minister in Trinidad had indicated that 1 from 10 leaves 0. And so Jamaica having left the Federation, we ended up with the Federation going at the time. And there is that whole logic of trying to tap into where the center of gravity is and where the focus is likely to be, and then ensuring that you move your argument in that way. And we're human beings as arbitrators, and we are tapping into the same way of thinking generally, which persons from a particular society, get back to what Yoshi had said at the beginning about cultural variance and all of that. You're trying to understand the culture of the people, understand how they function, what matters most to them. And then you tap into that by way of how you present, because ultimately as counsel, you want to present a winning argument. And there's no point in presenting a highly technical or a highly philosophical argument if at the end of the day, you cannot convince the persons you're trying to convince. That's my contribution.
I couldn't agree more. So we've spoken a little bit about how psychology can influence the way we make decisions. You know, arbitrators, like all of us, they're humans, and so they can be prone to intuitive decision making and be influenced by these kinds of subconscious psychological factors that we've been talking about. I'm interested to hear from the panel, what are some methods that can be adopted to ensure that decisions are being made consciously and deliberatively rather than subconsciously and intuitively, or at least to a greater degree?
First of all, you have to look at your position. In some cases, you do not want them to make a conscious and deliberate decision. So it's always a question of perspective. But if we want it to be, I think there is the overall and undisputed fact that a counsel needs to come across truthful, so that there is something the tribunal relies on and not questions every word that counsel says. And there's often the misconception that you should hide weaknesses of your case as long as you can and keep it away from people. That has an influence on trust, and the trust is the pillar of the decision making, at least on the subconscious part. So I would say that it is very important that arbitrators' concerns about cases or counsel's concerns about elements of the cases are addressed heads on, not hidden, not trying to sneak it away because it comes across sooner or later anyway. And that is an element of trust building. It might be somehow counterintuitive to say, well, you know, let's see if they come up with that point themselves, or they find out that element themselves. If it is an element which you are pretty sure the other side or the arbitrators come up with, you should come up with it, because, and I come back to what I said earlier, if they conclude themselves, it sticks much more in their brain than you want it to be. So rather you are fronting it, it has a double effect. It gives you trust because you're not just playing a story which is in your favor. You are open, you are giving also weaknesses in quotes away, and you avoid them making certain conclusions on the case. So if you do that, I think the tribunal will be able to make decisions much more based on a conscious decision than a subconscious decision.
Can I just make one comment? From my perspective, there are some difference between the civil law type of arbitration and versus a common law type of arbitration. And then, for example, for civil law type of arbitration, we have arbitrators quite focused on the cause of actions, and which is strictly related to this cause of action, this defense or this counter argument or something. So then, as arbitrator, I'm trying to kick out kind of unconscious effect on myself, then intentionally pick up the supporting evidence, which should be direct supporting evidence to this cause of action. And although my sense is catching, oh, this case is a quite A's case or B's case or something, but why is that? Then I would intentionally logically organize my kind of a logic supporting evidence, then cause of action, then legal effect or something. But of course, I agree with the Oliver's, the unconscious effect is going on, and especially for how persuasive and how kind of strong argument for each side or something. But as an arbitrator, I'm always kind of carefully kind of screening out such unconscious or kind of repeated background story or something. But if it's not the supporting evidence to directly to the legal cause of action, then I intentionally to kick out of those factors.
You're
Sorry,
trying to be conscious about the unconscious, Yoshi, is what I understood you to be saying, which I think is right? That's the point of departure. If you're trying to be more conscious in your decision making, you need to be conscious about the unconscious. Oh, sorry, Saoirse, you were going to say something.
Yeah, I was just reacting to what Oliver said about credibility as an expert. I mean, that's our duty, to be credible, objective, and really there for the tribunal. But then this sort of then deals with as you can imagine, it can happen where clients can be very keen to, if they're on the claimant side or counterclaim, for the number to be as high as possible because they feel that, well, the tribunal's bound to split the difference. So if the higher the number, then, but what I found that's not the case. In fact, by inflating, I mean, really, you will be hitting on your credibility. And I think this really goes to what Oliver's saying, and this is about, you want to be credible, and trying to explain that to clients is sometimes, you have to really say that this will be counterproductive to your case, and it doesn't really help. And I think this is helped by a PwC survey on damages that we've conducted around the whole, do tribunals split the baby? We had awards between, commercial cases and investment treaty cases, and they very clearly prove from awards that doesn't happen. There's no concept really like that, really. So this is really for going to the comment that Yoshi is making, that really tribunals, they do think about it and they do get some logic about it, but they're not persuaded by inflated cases. Maybe they're going to be fair, but they're really not splitting the differences. And that's from a quantum perspective.
Thanks, Saoirse. Just in the interest of time, I think now let's shift to looking at psychology and arbitration from the counsel or expert's perspective. Chris, you've got decades of experience appearing as both counsel and arbitrator. How do you go about preparing yourself mentally to make sure that you're in the zone when you're acting as counsel?
It's funny. I've had strange habits over the years. There was one point in my life when I used to practice 3 hours of Kriyas every day, Kriya Yoga. And that is a process where I would sit and I would reflect on the case, and I would literally go through the entire process before I get into it. So by the time I would have got into a matter, I would have cross-examined every witness. I would have made every submission I had to make and everything in my mind during my 3 hours in the morning. So that was a phase. I've kind of gone out of that phase. But I think generally what has happened with me over time is that I tend to process everything in my mind, every single thing, including every sentence I write before I put it on paper. And I tend to always, in my processing, try to think of how it is that I'm able to engage a witness as counsel, to engage that witness and to get them into the vortex that I'm interested in getting them into. And it differs depending on who the persons are. And I think in doing that, it requires some fair amount of intuitive assessment of who it is that you're going to deal with. And one of the things that has benefited me as well is that at some point in my life, at a much earlier point, I had some involvement in drama, on-stage drama. And I learned early enough that however prepared you are, when you get on a stage, you have to look at the audience and then recognize that there are times you simply have to change everything that you had intended to do. And even now, so that happens. So in my own preparation for cross-examination or anything, it is never, ever completed until after I have asked that first couple of questions. Because it is then I get a greater sense of who it is that I'm dealing with, whether I need to be a little more aggressive in my strategy, a little more compassionate in my strategy. All of those things it's a very dynamic process of preparation for me. And it is something which, if you were to ask me the 1, 2, 3, 4, 5, 6 steps that I take, it's a very difficult one to take because it is always dependent on the circumstances. And I say, of course, I know my facts, know the relevant law and so on that I have to deal with. But how I then engage a particular witness or engage the process is always determined while I am in the process.
Very interesting. Saoirse, what about you? You're an expert, and so you've faced cross-examination many times. What kinds of things do you do to make sure that you're in the right headspace when you're going to testify?
It's interesting listening to Christopher. I think we're quite similar in some respects in terms of, for me also, I want to be mentally prepared that, you know, in the room. So therefore, what is very helpful for me, if we have a physical hearing, to me to have a chance to have a look at the room. Preferably, I may go to the I think we've got some background noise there. Okay, thank you. To be mentally ready, and as we had there, be prepared for anything. So anything can happen, and you can prepare yourself to a certain extent. So as I said, maybe seeing the introductions, presentations from the council, which usually happens. It's usually helpful for me to go in there, listen to it, listen to the voice, listen to the, I would say opposition council, understand what's important to them. Tribunals may ask questions, what's important to them. Usually quantum experts are usually at the end, so right at the end, unfortunately. I don't know why, but that tends to be tradition. So therefore I've got a while to go, and therefore I would more get comfort. So I have imagination how the room looks, how it feels, how it would be looking if I sit in the hot box, where the cameras are, where the presentation screens are, so I can see. So I really am getting myself mentally ready, but also I'm fully aware that anything can happen. So you need to be ready to change things, adapt to things, but I really try and be prepared as much as possible. So that's on physical hearings. When it comes to online hearings, it makes me very nervous. Technology, you can't control technology. It certainly controls you. And I'm trying to really be, let's be honest, it's a stressful situation, and you want to try and reduce the stress as much as possible. So certainly trying to get on top of the technology, preparing whenever there's a test to make sure you're prepared in terms of the headphones, there's no feedback. But trust me, it can happen. It can, go wrong as well. And I remember my very first time I testified, we were in a hearing in Munich in a hotel room, and it was getting towards, as usual, quantum experts there at the end, but the stenographers had a flight to catch. And they just said, we have to go. And so as they were packing up and the tribunal sitting there deliberating, well, what do we do? And it was my first time in a hearing. I thought, well, is this normal? This happens. And as I found out now, it's not normal. It's very unusual. But then, then we found some mechanism to record what I was saying. But, it's just preparing for a situation and preparing to what happens, but also maybe to Chris's point around looking at the tribunal, understanding really what they're reacting to and reacting back to it. So it's about visually seeing how they're reacting, what their body language is looking at, and really try and react to what you think that they want to hear, as in terms of what is interesting to them. I'll stop there, Simon, for interest of time.
And just very quickly before we pass on to the Q&A, Oliver, I think you had some ideas about virtual hearings and how psychology is particularly important in that context.
Yeah, I'm happy to begin. That's the new phenomena to some of us during the pandemic. And you have to be aware that your communication, the vast majority of your communication is nonverbal. So in that setting of virtual hearings, this is cut off to some extent because you're not seeing body language properly. For example, just looking at the pictures here, you can only see my hands. Everybody else's hands are cutting off. You cannot see hands, feet, group interaction in the room, how people are giving each other a look. Let's just try to push a witness real hard. You look him in the eye, you push him hard. You cannot look somebody in the eye via camera. You either look on the camera or you look on somebody's eyes. It's not doable. So you have to be aware that these virtual hearings are very, very different from the live scenario. And the second element is that you lose a lot easier focus than in an environment where you are observed, where you feel that people are around you, because that's embedded in our brain from the ancient times when the brain was alerted that the lion or whatever jumps out of the mammoth, jumps out of the bush. So if you are surrounded by people, your mind is much more alerted than in a video conference where you sit alone. So what I want to say is it is a totally different setup where you just have to be aware of that difference. It's not good or bad. I find it bad in cross-examination, but it's not good or bad as such. Becoming mute or not mute might become the big thing, that my screen changes from bright to dark, might be the only thing you remember from the hearings. It's very, very, very distracting. So the other thing is, forget to read from a script in a video conference, because you're not authentic. Your trust element is impaired by you reading from a script in front of a judge or a jury. It might be, you might be tempted because nobody's around, you have the script in front of you and you read, but it's not coming through as you want it to come through. So what is in your control? Your background is in your control, either colors and clothing, that's a whole psychological element and different subject you want to get into. Camera positions, in my view, you should see people's hands. If you want to convince people, use your body language as best as you can on the camera, because non-verbal communication is key. And use tools of muting people and play with what you can do there. And always be aware, the more people in around, that the more distraction is there. So if, as an arbitrator, you might want to always have breakout rooms, especially if you're a mediator, Yoshi, breakout rooms are the key element of finding solutions. So know your audience and prepare in detail with these differences.
Can I make just a few points as the mediator? And also I'm the chair of the virtual hearing committee for the Japan International Dispute Resolution Center. And actually, for some, I completely agree with the Oliver's mentioning, but still some cases, like very, kind of a hard, tough domestic family dispute or something, very emotional. And then if you can use the remote hearing for such, mediation case between the, attacking each other or something. And some people would not like to be sit down in the same room. But if you sit in a remote, in a different world, they can negotiate and they can state what you think truly. So then that could be a chance to get the common interest between the parties. So for some cases, depending upon the atmosphere, we can utilize quite good psychological good effect for the remote, especially for the mediation case. That's mentioned by some Hawaiian lawyers even before the COVID-19. They have been frequently utilizing the remote mediation operation for such quite tough family case. And then for catching the your face looking at the eyes or such sense, some mediators is saying, to watch the face through the camera is much better than the real one. You cannot make your face to close your face in the real world, but if you are utilizing the remote camera, you can observe everything. That's what he's saying. I didn't agree, some extent, but still some psychological good effect we can utilize. And then I think such remote operation or option can be surviving as a kind of strong option, especially for the ARB-Med type of combination. That's my statement.
If I may comment quickly on it, Simon, quickly. And, I like to think... Sorry?
Just very quickly, Chris, we've got...
I know, quickly. In fact, I like to think that the LCIA changed its rules on remote hearing because of a matter I was involved in. Right at the beginning, we had a matter that moved from being physical into virtual in a matter involving two state parties. I was lead counsel for one of them. And what I found interestingly enough in the oral is that once you have good online, once you have good telemedia support, it changes a lot. And I have acted quite a bit from early in the pandemic and so on, both as counsel and as arbitrator in online matters. And I have found, interestingly enough, that there's instances in which I get to observe, certainly the tribunal, when it's a three-party tribunal, I'm able to observe them in a continuous way much better, depending on how the settings are. And I certainly found I was initially hesitant in that matter that transferred from one state to another. But by the time the matter ended, we were quite happy. And we were able to see things by reference to how we used our telemedia expert to get the matter managed. So I would suggest that once you're in that space of online, one of the very first things, it's expensive, it can be, but one of the first things you need to do is to get a good telemedia expert who can help you as to how you pitch your matter, as to how you position all the other things that you do, and spend a lot of preparation time prior to doing it, getting into the groove and understanding how you're able to match your telemedia evidence with the oral presentations and everything. I have found that it works very well.
Thank you very much, Chris. So now it's time for Q&A. We have one question from the floor already, and it's about the composition of the tribunal and how that can impact the way you tailor your evidence. So if you have, say, an engineer, a QS, and an arbitrator on the tribunal, as opposed to 3 legal practitioners, would that change the level of detail in the evidence that you file? So that, say, if you have a QS on the tribunal, you'd file much more detailed evidence. And I guess this question really goes to one of the points that we've been discussing, which is the background and experience of the decision makers and how their psychology that results from that will actually impact on the way you present your case. So very happy to hear responses from the panel in relation to that question.
If I start first, I think it does make a difference. And that's why you have to always be very much aware who is sitting in the room and who's sitting on the panel. Down the road, it does not matter so much as to using psychological elements of it. I think it's a little bit more on the content of the presentation. And if you have a panel which is not legally trained, and you have a complex case from the legal point of view, you need to break it down in small brackets and take them by the hand. Because, and that's with everybody, the attention span is usually lower than we think it is. Probably most of us are done by an hour. And then if the issue is complex and not your home turf, it's even faster. So the attention span is even shorter. So you need to tailor your pleadings and make decisive breaks, and then probably use the frame and saying, well, let's step back again from where we are after your break to pick up at that point where you left it. So in short, one of the elements is to use breaks deliberately and tailor your pleadings in small elements, which you repeat to a certain extent.
I can see we have a hand up. Aziz Tayabali.
Sorry, can I? Hi, everyone.
Hello.
Yeah,
Hello.
hi. You can hear me, right? Now, you see, before I ask a question, I've got some comments. I mean, I'm looking from the perspective of, from the point of view of an arbitrator. I must say thank you very much to all speakers, for your illuminating sort of points and all that that's been raised. But I heard a comment about something about fairness kind of thing. See, bottom line is, no matter how much of, I'm not denying the fact that there's always psychology in anything and everything that we do in life, right? And of course, we as arbitrators, being humans, we also have been affected in a sense when hearing a matter and all that. But coming back to fairness or unfairness, I think bottom line, isn't it not right then, basically, that as arbitrators, I mean, let's assume for a fact that there's one party is very good in trying to massage the ego, especially if you sit as a sole arbitrator. in contrast to, say, a three-man arbitral tribunal. And the other party is not so good. But the bottom line, I think, is, I think our role as an arbitrator is not so much about how our egos are being massaged, but rather the facts and the evidence, right? I mean, bottom line is, because we are here sitting, well, I mean, in so many words, as a judge, because the dispute is coming before us, and we have to decide the dispute, write the award, based on what has been presented to us. So, you know, despite whatever psychology that one particular party's counsel and the party themselves may play on the mind of the arbiter concerned, I think the bottom line is that, you know, we have to suppose to render a good award, which we feel should not be able to be challenged at the bottom, I mean, at the end of the day, right? And of course, it should be enforceable for the party to whom the award is, or, you know, it is being given to, in the sense that if we make a finding for the claimant, fine. If we're dismissing the claim of the claimant, therefore, you know, that it cannot be challenged by the, or rather, trying to be set aside in that sense, kind of thing. So what are the panel's views on this? I mean, would I be right in that sense? Because no matter what, psychology, yes, plays a part, but bottom line is facts and evidence. And it's something that we cannot run away from as arbitrators.
If I intervene there quickly, and I agree with you that every good arbitrator starts out with saying my obligation is to make an enforceable award by reference to the facts and the submissions. That's a starting point. However, every good arbitrator also knows that you can always massage the facts and the submissions to fit the decision that you have made. And in most instances, as decision makers, in any situation at all, we start intuitively with a feel for what we think is the proper position. And very often, the process is simply about helping us to either confirm our position or to have good reason presented to us as to why we should move away from it. And so ultimately, it is in that context that it becomes so important to ensure that you tap into the intuition and the intuitive thinking generally, rather than the much more deliberative way, because deliberation for all of us will always come down to how do we deliberate to support a position already adopted. And as lawyers, we know that as lawyers, we generally depart from a position of understanding a position and then being able to find a way to justify that position. So what I am saying here is that while I agree with you as to what our function should be, I am not so blinded, nor do I think we should ever be so blinded, as to forget the fact that we are operating by reference to human beings and that we all intuitively behave and think in a particular way, and we should expect that behavior of others. Yes?
Thank you.
Thank you very much.
One last sentence. If you think that you can see that somebody massages the facts, he didn't use his psychology elements right. Otherwise, you would not even notice. Yeah.
I like that. I like that. Sorry. Yeah.
So we have another question from the floor. And it relates to how you can deploy psychological insights and techniques in written submissions for counsel or in awards for arbitrators. Any views on that from the panel?
Yeah, this is a seminar of its own. There are priming techniques. There's the description of pictures, etc. How you use words. The famous examples of a study where eyewitnesses were shown a film in a video where a car crash happened, and they were asked once the question, at what speed was the contact made? And they said about 50. And then they were asked the same question, at what speed did the car hit instead of contact? And it was 55. And then the last question was, at what speed the car smashed into each other, and it was 70. The eyewitness, the same video, the same film, just using different words. I think that was an example which might fit to that answer.
from my end, just quickly, related to my previous comments, for the civil law operation and the legal system, we have to focus on the only cause of actions and kind of a skeleton type of simple items should be stated. But for persuading the arbitrators or decision makers, as a counsel, I'm always trying to state what's the real story in the background. And then, as Oliver mentioned, repeatedly in a different words, I really make an effort to kind of so-called mind control on the psychologically on the arbitrators, not only stating of the skeleton type of a cause of action, but what's the background, what's the real story, and where could be the related situation, something like that. I'm always trying to do that, even under the civil law type of operation.
If I add something to that quickly, I think in both as counsel and as arbitrator, it's understanding the psychology of politics, broadly speaking, not party politics. Cultural variance and all these other factors mean that when you write as counsel, you need to examine every word by reference to who is receiving it, questions of diversity, questions of all sorts of things impact what you write and the language that you use. Similarly, as an arbitrator, you will understand that there's an audience that is receiving whatever you're presenting, and there are political views being represented. I remembered Sir David Simmons, when preeminent lawyer, when he became a judge, Chief Justice, as he was in Barbados. And we're speaking, and he said the very first thing he did is that he went back to school to learn how to write better English. And believe me when I tell you that this man is preeminent in his writing, in his all sorts of things. Because he said to me that as a lawyer, his primary objective was to convince a judge and a jury when he had to in a particular way. But as a judge, stroke arbitrator, his objective was then to present a judgment that the person receiving it, oftentimes the average person, should be able to digest and believe in. And the skill sets are different. So in your written submission and in your written presentations in an award, you always have to bear in mind from the start to the end, and as you revise, what your audience is, what the political message, broadly speaking, not party politics, as I said earlier, is that you must convey what the circumstances are in which you're operating, what the cultural variance and other issues are that are at stake, and then try to fit what you're doing in that matrix. And if you do that and you do it consistently, I think you'll be fine.
I think maybe I'll just finish off at the end from the quantum perspective. Certainly our reports are written in a way because our audience, we're writing sort of loss of profits, valuation, quantum type reports, and our audience is mainly the arbitrators, counsel, and you are lawyers. So we need to make sure, and to be honest, the understanding of lawyers of quantum areas is very good, but we need to sort of pitch it in a way so really everyone understands it. And I think going, Chris, to your point around sort of making it understandable, it's communication and making it using simple language rather than being lost in lots of very complicated terminology, which we, as accountants, as valuation experts, we can do that. We can get very complicated and messy, but we need to explain it in a certain way. That's in terms of making sure our audience understands, number one. Number two, our language needs to be, I think, in a way that's not adversarial or too extreme. I think you really need to have language that is presented in a way that is not in any extreme way really, and keep the language simple and appear to be objective and credible. Back to you, Simon.
And please use more pictures and slides other than words, because you remember they are sticking in the brain much better than 1,000 words.
Sage advice. Well, we've run over a little bit, which I take full responsibility for as moderator, but I think we've had a very rich and engaging discussion with great contributions from our panel and excellent questions from the floor. Now, naturally, given the breadth of the topic, we could really only scratch the surface, and many important questions remain to be discussed another time, perhaps. So it remains only now for me to thank our speakers, Saoirse, Chris, Yoshi, Oliver, for their valuable contributions, and also thank the AIADR for organizing this discussion.
Thank you, Simon.
Thank you, Simon, and thank you, everyone.
Thank you very
Yes.
much.
Everyone, and have a wonderful rest of the evening or morning. So,
Thanks.
okay, bye-bye.
Bye-bye. Well, enjoy the rest of the World Cup matches.